There's a legal principle called the Public Trust Doctrine that stretches back in various forms to Roman law. The doctrine holds that legislatures and governments are trustees of the natural world with a duty to protect it to ensure the welfare and survival of present and future generations. Mary Christina Wood, who teaches law at the University of Oregon, is the author of a powerful book called Nature's Trust. She argues that the public trust doctrine doesn't apply only to forests, wildlife, and waterways, it also applies to the air that we breathe. That's the basis of what she calls atmospheric trust litigation, which calls on the courts to require that governments take swift and decisive action to reduce greenhouse gas emissions within their jurisdictions. The most spectacular such case is the Our Children's Trust case, in which 21 young people are suing the U.S. government for violating their constitutional rights by promoting the production of greenhouse gases through the use of fossil fuels. Instead, the children want governments to reduce their emissions by 6% a year. The Our Children's Trust case has been called the most important lawsuit in the world, and its roots are in the thought of Mary Wood.
I grew up on the banks of the Columbia River at a place called Woods Landing, and it's a salmon spawning site. So I grew up watching salmon spawn and the river flowing by in all of its various moods and in all of the seasons. And that affected my, I think, environmental passion. It gave me passion to protect these natural areas.
The place you love so often starts that, I think, for people, and then you saw that go away.
Yeah, when I was growing up in high school, the I-205 bridge came over the Columbia River, and developers started buying up all of the farmland and the forests and the wetlands, and within just a few years, the entire area around us became suburbia and box stores and just horrific development that was just filled with congestion, McMansions, and it was devastating to me because I grew up thinking this place will always be here just like it is. And even though I didn't own all the surrounding area, it became part of me to see it. And within just a few years, it was all lost. And that was tragic. And it's only one area this happened all across the country, of course.
Yeah, all around the world, really. So then at one point you write that you saw the destruction of the great salmon runs, and the colonial trustees upon this land had devastated it in a mere century, what the native trustees had managed with fiduciary care for millennia. At what point did that come to you in that kind of form? Because that's a very concise description of a very big problem.
So I grew up at an Indian fishing site, and so we would find Indian sinkers, which were evidence of native fishermen taking salmon right where the stream comes into the Columbia River. And I grew up with this sense of there's been people here for thousands of years. And then the salmon I knew had come back for millennia. But when I got into college and then law school, I realized that the runs were collapsing. And my own father would tell me of his memories of the great salmon runs from his childhood. And then in my early adulthood, they hit the endangered species list. And so it just struck me in a mere century and a half, these new states of Oregon and Washington devastated this natural bounty that had sustained human beings for millennia.
Presumably you've also been brought up to believe that the First Nations were sort of primitive people who didn't understand much and didn't have all our science and all that sort of thing, but that sentence recognizes a very different reality.
Yeah, I was not brought up to believe that the native people were primitive at all.
Oh.
I was brought up in a completely different way because my grandfather actually was a boy who lived with Chief Joseph of the Nez Perce for 2 seasons. And my great-grandfather was a friend of Chief Joseph. And so growing up, one huge influence on my life was my grandfather, who told me about the practices of the Nez Perce as he had come to understand them as a boy. And so quite the contrary, rather than thinking the Indians were primitive, I just had enormous respect, particularly for the leadership of Chief Joseph. And then when I started teaching at law school, I was handed the course Federal Indian Law. and I looked into the cases and became familiar with the treaty rights and the negotiations around those treaty rights. Yeah, really quite the contrary. I think that native systems are the most advanced property systems in the country, and that many leadership attributes are much more advanced than those you see, at least in the ecological arena, by the federal government and the states.
I agree with you, but I came to that quite late, because I think that, like a great many people of settler ancestry in this part of the world, there was this whole sense of the Indians as being a people who history had kind of cast on the sidelines as a more advanced people came into their territory. And it's taken a long, long time to recognize that that's a false way of construing it.
Yeah, again, just growing up and in the place I did and with the family I grew up in, we had really the opposite image, if you will, or the opposite reality, where we looked upon Chief Joseph as a great leader, a very wise person, a strategic person, and so I think I just had that different background.
Well, and the other thing is, of course, where I was growing up, I grew up in Vancouver, but I spent a lot of my...
Washington?
No, Vancouver, BC. But I also spent a lot of my summers in Point Roberts, Washington, that funny little enclave where Canadians have, the one place in the world where Canadians routinely outnumber Americans in their own territory.
And where is it?
Point Roberts, Washington. It's right on the border. It's a little point of land that sticks down from Canada, and the 49th parallel slices the tip off, so that in that 5 square miles on the tip of the point, you're in the United States. But you can't get to the rest of the United States except by turning twice through the border.
Oh, how interesting.
People do that every day with their school buses, for example. The kids go to high school in Blaine, and they have to go all the way around the bay to get there. But it's in the middle of the Salish Sea, and when I was growing up, there were often nights when there'd be 100 purse seiners all anchored off the tip of the point. And it wasn't very long before, well, that didn't last very long, And all of a sudden the runs were in trouble, and it's exactly what you described. I don't remember natives in Point Roberts, so I didn't have that, the other side of the coin.
Yeah, for me it was a profound way to grow up, to realize that we were the newcomers. Just by seeing these Indian sinkers and all along the fishing bank, basically, and seeing the same salmon come in, and then hearing about the fish and the abundance from my father. I mean, he just lived in a different era where there was a cannery down the road, and he described the fish as being almost up to the ceiling. And he and I went to a hearing one time together, he in his very old age, and I was a young person in my career. And he actually testified as to that abundance. And that was pretty sad. It was just, sort of an abundance that I know I will never see. And it was shocking that just within one generation, that could collapse.
It is shocking, and that must have formed of the way you went at the whole question, all the questions of ecology in general.
Most certainly. Mm-hmm.
Your book is called Nature's Trust, and I think a lot of people probably will not understand what a trust is. Can you talk about that?
A trust is a very basic concept. It's a concept of property law, and it basically means that where you have wealth, it could be natural bounty, it could be financial wealth, that is divided between owners. You have a trustee who has to manage the wealth for the benefit of a person or a group of people, and those are the beneficiaries. So it's different than private property. It's in the case of the public trust, it is public property of natural bounty that is really owned in stewardship and in common by the public, and government, as the entity that gets power from the public, has the duty and obligation to manage this natural bounty just for the beneficiaries, which are the citizens. And those citizens include present and future generations, because the public trust and nature's trust is supposed to continue. It's an ecological endowment that needs to last to sustain future generations of human beings. So it's a very simple concept, but it's profound when you confront some of our problems of environmental law with this trust.
Well, it sounds like it's a concept that's more in the breach than the observance. I mean, that's not the way that things are managed, right?
No, it's not at all. Because back in the 1970s, Congress passed a variety of statutes. And we know these statutes, they're the Clean Air Act and the Clean Water Act and the Endangered Species Act and a whole host of others. And when these statutes were passed, all of environmental law gravitated towards them. And all of environmental issues were sort of pressed through this statutory regime. And people forgot about the public trust. And so many people don't even know about the public trust, but it is the originating principle and a constitutional principle that binds our government. And today, as we see statutory law and regulatory law being so warped and so abused really for the benefit of corporations, people are turning back to the original concept of the public trust.
Well, very smart people who are in the lead on us are turning back to it. But do I understand you correctly that, in effect, the passage of what we thought were environmentally friendly, positive, forward-looking laws have actually turned out to be the instrument by which the very things they're supposed to protect have been degraded?
That's right, because the statutes have very noble purposes. They were supposed to protect our natural resources. And so all of the statutes start out with a prohibition against damage. But the problem is they go on to have permit systems embedded in them. And under these permit systems, the agencies can grant permits to allow damage, to basically legalize the exact damage that the statute was designed to prevent. And these permit systems were never supposed to swallow the statute. They were supposed to be the exception rather than the rule. But what happened was, over time, these agencies became captured. Industry just constantly pressured the agencies into giving permits. And once the agencies gave a number of permits, it was hard to go back and draw the line against damage. And so, quite ironically, the statutes, while they still protect in the sense that they do ban damage without a permit, they nevertheless have been used as instruments to legalize the very damage they were designed to prevent.
So you can't get in without a ticket, but here's a ticket.
Yeah,
right?
exactly. That's exactly right.
So your proposal is to go back to the original public trust doctrine and to, well, how come the courts haven't had anything to say? How come they haven't prevented that and gone back and said, no, 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 that's not the purpose of the statute. You've got to honor the original purpose of the framers, not act against this way.
It's a good question. Most environmental lawsuits have been statutory lawsuits brought under the statutes, either challenging regulations or permits. So they're very, very micro at the outset. And the courts have, over the last few decades, taken a real backseat to environmental law. And what they do is they review agency action in this box that we call administrative law, which is different than any other law, case. In most lawsuits brought by one party against another, each party has to come in and bring its proof and its experts and so forth. But in administrative law, we have what we call the deference doctrine. And the courts give deference to the agencies, both in their interpretation of the law, but also in their technical findings that underlie the permit issuance. And so with all this deference, the courts have said we won't second guess the agencies. They assume that the agencies are objective players. And the problem with that is that the agencies are not objective players. They're very politicized on both the state and federal level. And so they're very inclined to allow the damage under the statutes. And when you have the courts backing off, you basically lose any sort of check over a growing amount of power in the executive branch. So the courts have never been really positioned under statutory law to question the role of the agencies. And the public trust asks them to step outside of administrative law and look at some macro issues under the trust lens.
Which kind of preempts the next question I was going to ask, which is the judges are not stupid people. They obviously must know what's going on here. You would think that on occasion they would stop and say, wait a minute. This may be according to the letter of the law, but it's absolutely not the purpose of the law. We should be doing something different.
Well, many judges have had very strong opinions overturning regulations, sometimes permits. But my point is that any case coming under statutory law is going to be micro. So the statutes operate on an action-by-action basis. agencies pass regulations or they issue permits or both, and challenges are micro under those statutes. And so if a case comes in and overturns an agency action, number one, it's usually micro in scope, having to do with one regulation or one permit that affects a whole body of the environment. It's a micro action. And then when the court overturns the action, finding it was illegal under the law, they often remand the whole process back to the very agency that came up with the poor determination in the first place, without oversight. So the salmon is a great example, the Columbia River salmon. Those salmon have been in litigation for 20 years, and they still have not really come on the road of recovery, even though there have been judicial opinions time and time again finding that the agencies didn't act in accordance with the law.
But that hasn't changed anything. It doesn't require them to go back and act differently. You're tied up in litigation more or less indefinitely.
Well, I think the salmon litigation is extraordinary because for years the court was finding violations of the Endangered Species Act without really any appropriate remedy. They would just remand back to the agency. Judge Redden actually broke that trend, and he forced the Corps of Engineers to allow spill through the dams in the river because he found that the fish would go extinct potentially without that. And so he was one judge that forged ahead and actually had an injunction that made a difference on the ground. And I think that has made a difference with the salmon, but it's the salmon have still not been recovered. The biological opinions are still under litigation. And it's difficult for a court to really find its role when it's dealing with an agency that is very politicized.
And does have the authority to manage the species and situation. So if we go to the Public Trust Doctrine, this is a way of stepping right outside that box. Is that?
It may be in some circumstances. So the public trust is outside the statutory box. The public trust represents the obligations of government towards the citizens. The statutes represent how government is carrying out those obligations. So the statutes themselves may be deficient, and the regulations from those statutes might be deficient. But the public trust says, evaluate the government's actions from its constitutional duty to the people. So you're not trapped in that statutory box when you bring a public trust claim, because cases time and time again say that where the government acts pursuant to statute, even if it abides by the statute, it may not satisfy its public trust obligation to the people.
So it does give you another whole avenue that does go back to the root of the problem, right? Goes back to the issues that are fundamental to this.
It does go back to the root, and I think one of the strongest places that public trust litigation can go is to explore the duty of loyalty to the citizens. Because the basic problem with government is that it is operating on behalf often of big corporations. We certainly see this in the current Trump administration. We saw it in the Bush administration, but also in the Obama administration, just to a different degree. But when government acts to further the interests of a private party or big or a corporation over the interests of citizens, it's violating this duty of loyalty. Because a trustee has a singular duty of loyalty to the beneficiaries. The beneficiaries are the present and future citizens. So oftentimes we see, if we go beneath these regulatory decisions, we see a lot of pressure by a private party or a big industry, and we see that the decision caters to their interests instead of the public interests. And that, where there is bias, where there is self-interest on the part of the decision maker, then that is a violation of the duty of loyalty. So if we take this even into the campaign financing context, we know that many legislators are financed by big corporations that stand to benefit from easing up pollution laws. And when these senators or representatives receive campaign financing, they often vote against environmentally aggressive regulation. Well, that is right there a violation of their duty of loyalty, because these officials, these legislators, are trustees. The legislative branch is the trustee. As such, they would owe a duty of loyalty to the citizens. And so when they accept campaign contributions, that may be perfectly legal under Citizens United, but it is not appropriate to then decide how to manage the trust, because there's bias and self-interest from that point on in their decision.
So in effect, they disqualify themselves by accepting the funds.
This has never been tested in court, but just as a basic trust principle, it is the elephant in the room. It's waiting to be litigated, and it is the core of the rot that we see in government. So it would be nice to actually get at that.
Yeah, it would. You must know Thomas Lindsay. His comment, one of his comments about all of this has been a really wonderful education for us, you know. But one of the things he points out is that the structure of law is really designed to foster trade and commerce, and that overrides community interests in a lot of these cases. But I think what you're saying is here's another instrument that could conceivably be used in that same circumstance.
Oh yes. The public trust can be used when you have essential ecological resources at stake.
So it's a very powerful concept, isn't it?
Well, it's very powerful because it is the only constitutional concept in environmental law that really holds against the kind of government activity we're seeing today in the Trump administration. So we're looking at an administration that wants to wipe much environmental law off the books. There is nothing in statutory law that binds Congress, because Congress makes statutes. That's its job. So if Congress wants to change statutes, it can do so under statutory law. If a president wants to change regulations, it has a lot of discretion to do so. But the public trust is that one area of constitutional law that forms a check on what the government can do. That's the whole purpose of the public trust, is to position the judiciary in extraordinary circumstances to say, no, your authority does not go so far as to destroy the essential resources that the citizens need for survival. Because the premise is the social contract really underlies the trust. We, the people, would not give our government the right to destroy our resources. The government literally doesn't have that power in a democracy. So that is the logic underlying the trust, and that logic has been borne out now in a few opinions.
I'm struck by the fact that another sort of parallel is Roger Cox, that you probably know from the Netherlands, who was the lawyer in the Arenda case, where the foundation that sued the government of the Netherlands for not doing enough about emissions.
That's an Atmospheric Trust Litigation partner case.
Yes, it is.
It's all part of this movement to sue government for not fulfilling its obligations to the people. So although it happened, it took place in the Netherlands, and although that case didn't use the term trust, I include that in the broader realm of what I call atmospheric trust litigation, waged now worldwide by children and their parents against governments for not doing enough on climate.
And what interested me there, the link that sort of caught my eye, is that one was the subtitle of Roger Cox's book, which is Why Only the Law Can Save Us Now.
Yeah.
And you know, as we talk about the public trust, we're up with the same, basically with the same sort of concept, aren't we? That the law says thus far and no further, and no, you can't legislate your way past that boundary.
That's exactly right. And he was writing his book at the same time I was writing mine. And we both arrived at the same conclusion that the law has to come in, the courts have to come in at this point in human history and set parameters for climate action, because we literally don't have enough time to squander more in the legislative and executive branches, and they are paralyzed. They cannot move forward without judicial oversight and enforcement, because they are co-opted now by the industries that they are supposed to regulate.
Yeah, so essentially we've got democratic rot that needs these people are not responding to their fiduciary duty, basically.
That's correct, and what most people don't know is that there was a principle designed long ago in 1892 by the Supreme Court of the United States that has roots even tracing back well before then, back to Roman law. There's a principle designed to prevent just that, because This is no surprise in government. This is an expected thing, that sometimes government will go astray and would jeopardize the welfare of the people they're supposed to represent.
There's great wisdom to be drawn on, isn't there? There's another thing Tony opposed in the Philippines, and I'm curious to know if you'll find this as you go forward with the atmospheric trust litigation. But Tony said that when he sued Factoran on behalf of future generations, Factoran was delighted because he wanted to do the right thing, but he was being kept from it by the pressures from government and industry. Tony says, so the suit put wind under his wings, which I thought was just one of the greatest phrases. But I wonder if you're going to find that as the public trust litigation goes forward against some of these agencies.
Well, it's interesting, in the oral arguments in the Juliana climate case, which is the federal public trust case holding the federal government accountable, in oral arguments, Judge Ann Aiken asked the Obama administration lawyer, wouldn't you welcome a rule for the court? This was particularly since President Obama was going to leave office soon. And at the time, perhaps people didn't predict that Donald Trump would become president. But the Obama justice attorneys completely missed the point. They could see no further than their briefs. The Obama administration Justice Department, like every other Justice Department before them, doesn't have the lawn view. They don't see the potential for dangerous runaway heating coming out of the fact that we don't have an adequate check and balance anymore. So really, government lawyers, particularly Department of Justice attorneys, should see a role of the court. But they have dug themselves into a position on both the state levels, these are state attorney generals as well, they've dug themselves into an identity where they just defend the government position. They're not really thinking about the public as their clientele or the broader implications for democracy that arise from their advocacy. So they come into court always just defending the government actions and not looking at the court as a potential institutional partner in keeping the government on track, even though the judges are seeing that potential now.
It's interesting to me because there was a proposal, or there was a thought between the election of Donald Trump and his inauguration, that was the point at which the Obama administration could have basically forestalled all of this by simply consenting to the, I'm not sure what the technical phrase is, but essentially saying, okay, let's settle this. And once you've settled it, then it's finished. I mean, you're not going back into the court to unsettle it, you know?
That's correct. The Obama administration had a huge missed opportunity that may go down as one of the worst missed opportunities of that administration. That was between the time when Donald Trump was elected president and the time he took office. Even Secretary Kerry told the world the Obama administration is going to do everything it can to secure a climate legacy for the children. Many, many attempts were made to convince the Obama administration to simply enter into an interim settlement that would have bound the Trump administration. And it would have, depending on how it was crafted, it would have stopped potentially even the Keystone Pipeline and Dakota Access Pipeline from coming back, at least during the duration of the trial. The Obama administration apparently refused to enter into the settlement despite multiple attempts by the plaintiffs and others. And that was such short-sightedness. And I wish that I could understand what was the role of the Department of Justice in this 60 days, these crucial days. Was this something that the Department of Justice, which is the intermediary between the plaintiffs and Obama, was it something the Department of Justice just tabled on its own? What was its role? Those questions are really important now because Department of Justice frames the litigation position of the United States in all of these cases.
And it may have, are you suggesting that it may have opinions of its own, that it simply doesn't refer upstairs?
It could. And I think that's a danger in how our cases are litigated. Department of Justice gets them, or the Attorney General on the state level gets these cases, and they create litigation strategies and positions, and only they really know how they formulate those positions. The public really doesn't know and doesn't have access to that. So that is one big black hole that would bear investigation.
Sounds as though their elected masters don't know either, because that's kind of because I often find that bewildering. I mean, I know that the Obama administration was pretty serious about trying to do serious things about climate, and it just seemed to me like it was such a no-brainer to make a settlement in this case.
It seemed very obvious.
Yeah. So you wonder if that argument even got to
one wonders, and there's really no way I know of finding out.
Yeah, you could ask Barack Obama, I suppose, at this stage of the game. There's another distinction that you draw in your book between the politics of scarcity and the politics of abundance, and how that relates to a lot of these issues. Can you talk about those two things? Because underlying all of this is something about the politics of scarcity that has to do with how we think, right?
Yes, I think the state and federal managers approach our natural resources using what I call the politics of scarcity. They look at the resources and their dwindling nature. They assume that is just a reality of the industrial life, that we benefit from all these products and consumption, and that our natural abundance just decreases. And then when you're faced with a declining resource, the major job of the government is just to split the benefits up among various parties. The politics of abundance was a term I used to describe the tribal position in many resource disputes. And what the tribes will often do, particularly here in the Pacific Northwest, they'll look at a situation of scarcity, and rather than just focus on dividing the few crumbs that are left, whether they're salmon or trees or whatever, they will often focus on how do we restore the abundance of this resource so that everybody can share in the benefits and get our society on a more sustainable path. And so they're often the ones, the tribal leaders are often the ones who come in with real vision. And they come in with not only vision, but heartfelt protective instincts towards the natural world. And there's a lot of spiritual and cultural underpinning to that. But it's very stark in how it contrasts with the antiseptic approach of state and federal managers. They come into hearings and they really aren't interested in stories of the community suffering, stories of a legacy lost. They are interested only in the particular standard emanating from the particular regulation that they're implementing. And on one hand, you can understand that. They are in such deep rabbit holes from the statutory law, they're not really allowed to look at anything else. And yet, oftentimes in local hearings, the very demeanor of the officials presiding at the state and federal level almost indicates that they just can't see a bigger picture. They're legally, hemmed in, and they just don't have the cultural platform to come in with a vision and inspiration that these tribal leaders tend to come in with. These tribal leaders come in and often bring a rich ancestral memory and cultural context, and they honor the what we call the resources. And I think their leadership, frankly, in this region, in the Pacific Northwest, I think the tribal leadership is actually gaining a lot of citizen attention from outside the tribal membership.
I think that's broadly true. I think that more and more and more thoughtful people of settler ancestry are looking at the way that the First Nations, and which is, I guess, the Canadian phrase, but looking at the way that the natives are defending the natural world and the feeling that the natives have for the natural world, and they're sort of saying, hey, wait a minute, these are the people that we really need to be in cahoots with, these are the people, and
Yeah, what's amazing is really the native nations have sovereignty, but they also have a broader cultural context. And of course they have history going back to time immemorial. And so when you have, the state and federal bureaucrats or officials lining up with tribal elders or leaders, there is a very vast difference in the appeal, just the appeal of their words to average citizens. Average citizens are starting to think, it makes sense to be connected with our ecology, not just to slice and dice it up and permit out its destruction, but to understand the community, the values, the family stability, and to situate all of that in a holistic context, rather than just allow the next mountaintop removal, the next toxic pollution, the next carbon emission, the next oil project.
And for what, in terms, you get to consume, you get something to consume, but basically what you're doing is generating garbage with much of that.
That's true, and environmental law also rarely asks, what are the intended benefits of a project? Now, the National Environmental Policy Act will look at alternatives to the action, but it never really asks the basic question, is this damage worth it? It's a procedural statute. It never gets to the crux of the matter. Who's benefiting from this? Who's profiting from it? Are the decision makers biased in some way? Never gets to those deeper questions, which are really infecting our system of law.
Well, that's right. And there is that sort of just the basic assumption that all of this is progress. And what it actually is increasingly large landfills, ultimately.
Well, increasingly, environmental law is leading to vast sacrifice zones. Mm-hmm. And so it's not just a landfill here and endangered species here. These are actually sacrifice zones developing. You can map them out. Louisiana is losing so much land per day because of channeling done by the oil and gas industry. You've got dead zones now, some the size of Connecticut, cropping up around the world's oceans. Appalachia is devastated. Communities have been forced to leave because of the coal mining industry's practice of blowing off the tops of mountains and then just dumping what they call the overburden, the mountaintop basically, in the little hollows below where communities have lived for generations. So these are, and then the fracking, all of the contaminated groundwater, and the assault on communities across this country and countries worldwide. Largely, it's attributable back to the fossil fuel industry.
And largely, it produces benefits for very few and for a very short time.
Yeah, it's difficult because we hear of jobs, jobs, jobs. So every proposal comes in with the prospect of jobs. What we don't hear about is the alternative. Is there an alternative energy scenario here that would support community stability, that would provide more jobs? We know that in many cases, the renewable energy industry is actually producing more jobs than the oil industry or gas industry or coal industry. But environmental law doesn't give us that part of the picture. Environmental law keeps us very, very focused, sort of has blinders on. Whatever action comes before a permitting agency, you ask, what's the damage from that action? But you don't get the bigger picture of, is there a vision for this community that has jobs, that has stability, that has health for our children? We don't get that picture in the rabbit holes of environmental law.
Yeah, that's right. It's all seen in isolation, which takes you back in a way to the native perspective versus the sort of statutory perspective. It's a very collective one, but as opposed to a very individual one. But the First Nations see themselves in relation to the world around them as being very tightly connected to that, and also very tightly connected to their own people in backwards and past and forwards in the future, which brings us back to the public trust.
That's very true. The public trust does the same thing. It looks forward to the future generation. So every public trust case I've read defines the beneficiaries as present and future generations. And so if you did want to line that up against the traditional native concept, you would say there's an element of the seventh generation in this, this ancient law that has informed non-native cultures as well.
Yeah, there's a real congruence between different words, but essentially the same perception. Okay, so now is this the core of it? Public trust doctrine is well established, but a neglected legal principle to start with. And it's associated with the politics of abundance rather than scarcity. It requires that the governing authorities act as trustees for the people of the future, and if they're failing to do that, then citizens can and should apply to the courts to require that the authorities do their legal duty. Are we close to the nub of the matter there?
Yes, so the public trust, both its strength and its limit, is that when you get down to enforcement, you have to look to the courts. Certainly citizens can take this public trust and assert it in hearings, before legislative processes. They can assert it in the newspapers, they can assert it all over the place, and they should. But in the end, if you have an agency that has a political operative as its head, and that is to say that political operative might have come just from industry. Like, let's take an example from the present administration, Rex Tillerson. One day he was CEO of Exxon. The next day he's head of Department of State. And this was true in the Bush administration as well. So where you have political operatives in agencies, they are going to carry out their agenda really on behalf of the industry they left. And when you have that, citizens can appeal and present the public trust time and time again. But if they are being pulled by self-interest towards whatever, and I'm not making a statement about our Secretary of State right now, I'm just saying generically, where you have political operatives, there's a danger that they might be pulled towards this industry interest. And so then the only way of really enforcing the trust is to go to the courts. Now, you can't take every single environmental harm to the courts and enforce the trust. And you shouldn't, because the public trust is a constitutional concept. But where you have, crises on the horizon, like climate crisis, then citizens really have to go to the courts, because that's where we get enforcement. It's the third branch of government, and that was the branch that was neglected at the macro level for decades in environmental law, because most of the power was collected in the agencies.
Well, and also, if you're appealing to the political operative at the head of the organization, that person is under no obligation to listen to evidence, to respect the truth, and do any of those kinds of things, but the courts are. Right?
Yeah, I guess, they are under an obligation. Statutory law requires them to act in a way that's not arbitrary and capricious or not in accordance with law. But the problem is you never know what that is until you take it to court. So the third branch, I think Americans in general for a long time kind of forgot about the third branch of government in the environmental law arena, because they see these agencies, and the agencies have all the power. They're the ones issuing the permits, they're the ones holding the hearings. But the courts are ultimately the only ones who can enforce obligations that the agencies have to the people. So the courts, we have three branches of government for a reason. The founders created our system of government and comprised it of three branches so that we would have this tension between the branches, and so that one branch wouldn't take all the power and run it into a tyranny, which is frankly what we're looking at. We're looking at an ecological tyranny because all the power has been amassed in this executive branch.
The impact of really making powerful use of the public trust doctrine, which is ultimately where this discussion goes, is really to create a kind of a revolution intellectually and administratively, and across the board kind of. And it's very powerful because you're not also thinking just of the United States, you're thinking about the same sort of thing, that this same sort of procedure goes on in many other countries, which presumably means that all those other countries have some version of the public trust doctrine embedded in their legal system. Is that right?
The public trust is known in legal systems throughout the world because its origins actually trace back to Roman law, which declared public rights in certain resources like air, water, shorelands, etc. And so because that Roman law expressly recognized public property rights, legal systems throughout the world have these seeds of the public trust in them. Now, some countries like India and the Philippines have expanded and interpreted their public trust in a very broad way, even broader perhaps than the United States. And so what we have here is a principle that can be used in almost any country except for the complete tyrannies. This is a principle of democracy. It doesn't, where you have a tyranny, you have no power of the people. And so, but in every other aspiring democracy or democracy, the public trust is a principle that could be used. And what we see in countries throughout the world is that many of them have, most of them have the same problems of corruption or corporate advancement that we have in this country. They have agencies that issue permits. They have very similar environmental laws because those environmental laws were patterned after our environmental laws. And so many of the same problems we've been talking about in this country are evident even to a greater extent in other countries.
And this remedy would also be, this type of remedy would also be.
Yes, the reason I focused on the public trust as an anchor for climate enforcement is because it is known in countries throughout the world. So I thought this is the one principle that may give rise to an obligation that could be universal towards our atmosphere, that countries of the world are in essence co-trustees of a common trust asset, and that is the atmosphere. And as co-trustees, they share the fiduciary obligation to protect the atmosphere. So that you could take this one principle, because it's so manifest in these other legal systems, and you could have court decisions in other countries, cases brought by citizens against their countries trying to force carbon reduction before it's too late. So when we talk about decisions in other countries, like in Pakistan or the Netherlands, those are decisions which, even if they didn't mention the trust, they would be part of this concept of citizen enforcing obligations to protect the climate. They're all part of the same cloth.
Yeah, and why only the law can save us now, that wonderful Roger Cox, that wonderful phrase of his, and you're right there, aren't you? These cases are cropping up all over the world, and if they haven't reached the courts yet, they're being, by the citizens, or considered by the NGOs and so forth. It's like this is...
That's right. There's cases being formulated now in France and England, Australia and Canada, you know, all sorts of areas. There's already cases ongoing in the Philippines. And they look different in Pakistan. Different countries have different cases, and sometimes they're formulated in a different way and geared at a different problem. The one in the Philippines, which is a public trust case, is geared towards reconfiguring the whole road system so that it is not automobile dominated. That might be the way to reduce fossil fuel emissions in the Philippines. But it doesn't look exactly like, say, the federal case in this country, but they're all part of the same cloth. He's fashioned that case to be part of this whole global movement of holding governments accountable.
Well, and you know, the public trust idea, the whole concept of that, actually would apply very, very widely to all kinds of other things.
Yes, and the public trust cases on the books do make clear that fish and wildlife are part of the public trust. And there have been fisheries cases in the past under the public trust. But when environmental law took hold, the statutes really sucked the oxygen out of the room. They really became the dominating focus. And for good reason for a while. I mean, they were sort of the...
fought to get them, right?
Yeah, people fought very hard and people thought they would work, and they had very laudable goals. And they were very specific. And people like predictability and specificity. No one could have imagined back then that the agencies would become so politically captured, because everything, the entire assumption underlying this statutory body of law, it's all grounded with one assumption, and that is that the agencies are neutral, objective entities that represent the public. And had that assumption held up, we would not be in this position we're in right now. Yet if you talk to people within the agencies, many get very defensive. They for good reason. They don't see a way out of this political capture that they're in. Many agency people are very frustrated by this. So this is not to suggest we don't have good people in agencies. We have heroic people in the agencies. And what I would like to see is the people within the agencies using the public trust to turn their agencies back on course. Because the citizens can't just bring lawsuits for every bit of environmental damage. It's not possible. So at some point we have to turn to the agency people and the career people and say, you all take this public trust, gather together within your agencies and try to right the ship a bit.
We're back again to our wonderful mutual friend Tony Aposa and his wonderfully imaginative approach to these things.
Yes,
being very
exactly.
helpful to
Yeah.
Tony. But he also talks about another agency that has to do with shorelines, and then once there's a court order that says you have to do what the legislation says you're supposed to do, then he can go out there and he can say to the Marriott Hotel, no, you can't build your hotel on this beach, and I'm terribly sorry, I'd love to accept your blandishments and your money and so on, but I've got a court order. I'm in contempt of court if I don't enforce this legislation, and that's really the end of the conversation.
Absolutely. I think it was, was a colleague who said, discretion throws the biologists to the wolves. And when we have all this discretion in the agencies from statutory law, these career people, these really dedicated biologists and permit writers, they are forced into this political paradigm, and there's just no out. There's no winning against that. There's really the fidelity that they felt to the law going in gets warped in that context. And so if they did have parameters set by a court, set by obligations to the citizens, they would be freer to enforce the law.
Yeah.
Without compromising their own self-interest, which is to keep their jobs.
That's right. That's right. It's a way of giving them an opportunity to be the honest people they wanted to be.
Exactly, because the political operatives come in and they use the job security as the ultimate threat against the biologists and the permit writers and so forth. So it's all about job security, and everybody knows that. It's just not even a secret anymore. This is just the elephant in the room that people acknowledge, but they haven't found their way out yet. And I guess my point is that the courts really need to set this parameter. The courts need to be an institutional player in environmental law. And so judges hopefully will recognize that before it's too late.
Another dimension to this that's been sort of dawning on me over time, and this discussion really brings it to the forefront, a huge amount of the difficulties that we face come from privatization. And I mean privatization going way back to the Corn Laws and the enclosures and all of that kind of thing. Again, if you look at the First Nations, there's no concept of ownership of land. Big Bear says, how can a man receive land? From whom would he receive it? But the moment you get that, you get a whole bunch of different motivations, and well, you get the politics of scarcity, don't you?
Mm-hmm.
Right?
Yes, and I think that the public trust is it's a doctrine of property law. So when you talk about privatization, it is the restraint against privatization. The only way anything is privatized is through government action. In other words, government has to say something is private to be private. And the only way it's private is if it actually has the enforcement of the government against trespass. So I think what would be a good thing is if more Americans and people generally across the world could think of our environmental problems as property problems. That in fact, government is acting in various ways to privatize things, even if they don't say they're privatizing. When we have coal plants or permits given to pollute, we are essentially privatizing a resource because we're allowing a resource. We're essentially privatizing a resource because we're allowing the monopolization of that resource. We're allowing an industry to pollute it or destroy it, and that means the citizens don't have the benefit of it anymore. So the public trust comes in as the doctrine, the principle of property law, saying that some things can't be fully privatized. And you need that.
Because they are inherently and inalienably public property.
Correct. They are inalienably public property. So my point is, you need that doctrine in property law. It doesn't work to just have some concept outside of property law. You need a concept that heads straight towards this privatization problem. Now, a good example is with water commodification. So companies across the world are trying to buy up scarce water supplies for bottling plants. And what they're doing is they're getting permits from the local governments to actually privatize a water supply. The public trust comes into that situation and could say, if enforced by courts, no, there's no way you can privatize it because water is in the public trust. And so government, you can allow use of water perhaps for certain things that benefit the public, but you can't privatize this resource. It is off limits. And so, many commentators say the public trust should apply to, and does apply to, water resources. You can also have other concepts, like community rights concepts, but they will never take the place of the public trust because the public trust has to be that anti-privatization principle on a constitutional level to combat what is otherwise a very dangerous trend towards corporate monopoly of our last resources.
Even the air, and including the sunlight.
Yes.
This is one of the, I guess, the benefits of getting older, is that you find yourself and you remember that, no, that's not the way it's supposed to be, you know?
Correct, and it's compatible with community rights approaches. The public trust is very compatible, but a community rights approach doesn't nullify the need for a public trust approach. It is constitutional, and it goes back to ancient times, and it is the anti-privatization principle in the law. It's recognizable by courts.
Let me take you finally back to the specific one that you're directly involved in, which is the Our Children's Trust case here in Oregon. That's thus far seems to have gotten remarkable amounts of traction, right?
It is. I'm not involved in the litigation. I originated the approach that led to these cases as an academic. But the lawyers taking it forward are with Our Children's Trust. And it is an absolutely path-breaking case, an opinion rendered really at this last moment of opportunity to avert runaway climate heating. And the court there declared both a right grounded in the public trust, but also in the due process clause of the U.S. Constitution to a stable climate system. And I think it will go down as an opinion that was crucial at a point in history. In other words, it's already a historic opinion because of not only the foresight of the court and the scholarly way the court analyzed these two rights, but also because of the time we're in. This climate crisis was anticipated by government and by industry decades ago, and yet the government pursued this fossil fuel policy that it knew to be dangerous. And the trial, I believe, will prove all of this out. But even the government reports that exist right now show that government knew of this danger for decades. And so just by virtue of the circumstance we're in, we're at the last possible moment before the window of opportunity closes. And that makes this really, I think, the most important case on the planet and the biggest case on the planet. I call it the case that has the planet on its docket, literally, because the importance of this case cannot be overstated. It affects every living being on Earth today and also all foreseeable generations, because we know that we are at the end of the road and that the U.S. has the lion's share of emissions. We also know that there's atmospheric trust cases teed up, either pending or about to be filed, in states across this country and also in other nations of the world. And so this opinion sent a signal to judges handling these other cases. And what we really need to have happen almost overnight is a judicial movement, is all the judges in all of these atmospheric trust cases reading this Juliana case, taking it as a beacon in essence, and rendering very clear opinions about the duties of governments across the world and across this country to reduce greenhouse gas emissions urgently. And then I do hope, I know the Juliana court has made very clear it understands the nature of the remedy requested and the role of the court in supervising that remedy. And other courts, too, I hope will come to understand that these are not cases that just sort of get resolved overnight. These are cases that anticipate a judicial role of oversight as carbon reduction plans are carried out. Because if you remove that judicial role of oversight, you go back to the story of the Columbia River salmon, where for the first decade of litigation, there were great decisions, but they were just remanded to this agency. We don't have time anymore for the political branches to just act on their own. This will need judicial supervision at all levels, whether you're talking about a state or a country like France or England or Australia, or the federal government of the United States. It takes the third branch actually supervising a remedy, very similar to what's happened in the Philippines with the Manila Bay litigation, where the Supreme Court actually supervised the cleanup of Manila Bay, and the agencies did the work of figuring out how to clean it up. The court didn't figure that out, but the court supervised the plan that they came up with.
And there was a very clear example of that also in Argentina, where the court essentially said, this is what's going to happen, and the different levels of government, different forms of government get together to form an agency. The agency will deliver on this plan, and there will be a timetable, and there will be penalties for delay, and you're going to be back here every month giving us a report on how you're doing.
So that is exactly the model.
Yeah.
And this model is called institutional litigation in this country. It's just never much been applied, not never, but it has not frequently been applied in environmental law, because environmental law was always brought, challenges were always brought within the statutory system. And so the courts would basically remand the case back to the agency. But this idea of courts supervising a remedy has been, tested time and time and time again in this country, in the prison context and the educational funding cases going on in Washington. And so once we step outside of the narrow confines of what we know environmental law to be, we see this as a remedy that courts can and have used.
I think India has also made big use, I think it's known as continuing mandamus in some circumstances.
Continuing jurisdiction, basically, and continuing judicial supervision.
Yeah, I've been watching this case with great interest, of course, as I think a great many people around the world have been, and it's been wonderful to actually hear some of the defendants over this weekend here in Oregon.
The plaintiffs.
Plaintiffs, yes, sorry, the plaintiffs, the defendants. Yes, absolutely wrong. Didn't want to hear from the plaintiff, from the defendants, right? Thank you very much.
Thank you so much.
I really appreciate this. And I have the sense that your work in bringing the public trust doctrine kind of back into the limelight is likely to have particularly a moment when we're all so much in need of new instruments to deal with some of these issues. I have a sense that this is a stone that will ripple to the shore in places we don't even begin to think about, like, say, salmon aquaculture.
I get emails from people from all sorts of places encountering all sorts of issues, and they do see the public trust it rings with logic. It's the logic of our democracy. It's the logic of our social contract with government. And people are waking up now and seeing that they too have inalienable rights in the area of ecology, not just First Amendment freedoms and other freedoms we tend to think about, but rather that we have ecological rights. And the profound impact of that Juliana opinion is that for the first time ever, a federal judge explained those rights in a way that the people can understand, but also in a way that honors and gives meaning to the constitutional precedent of our judicial system.
Two things. One of them is it provides us with better instruments for living together in time as such, right? As a community in time. The second thing I thought you'd enjoy is our researcher, when I asked her to look into preparing me for and sending me some stuff to prepare for this, read the decision and she said it gave her goosebumps. How does it make you feel when you think about, like, you started a rock rolling down the hillside here, how do you feel when you contemplate the possible implications of this?
How do I feel?
I mean, as a person, you know? I mean, you wake up in the morning and you think, what have I done? Right? And,
no, it was the visional lawn of mine to just bring the public trust to the people and to the judges. Not only the people of this country, but I do feel that there's a planetary patriotism rising across this world, and that everybody, whether they're in Uganda or Pakistan or Australia or the United States, that everybody now feels this sense of rising to our moment in time. And that the public trust, it stirs something within everybody, because the common citizens of the United States actually share more with the common citizens of Costa Rica and Ukraine and Japan than they do with their own governments. And so we all face the same problems and the same urgency. And I really did think that if I could just write a book that would bring the public trust to the people, that there would be just no end to how different citizens would apply that concept against the threats of their communities. So I hope that is true. And this is a moment where it's going to take everybody, every single person on earth, just diving in and using whatever resources they have to prevent, at this point, the prospect of runaway planetary heating.
Mary Christina Wood, the law professor whose thought provides the foundation for what may be the most important lawsuit in the world. If you're interested in the use of the law as an instrument for the defense of Mother Nature, you'll want to look at our Green Rights project at greenrights.com, which examines more than a dozen pioneering legal actions from all over the world. We've also interviewed the great climate scientist James Hansen, who is a party to the Our Children's Trust lawsuit. And take a look at our interviews with Roger Cox and Marianne Manesma, who successfully sued the government of the Netherlands to meet its obligations on climate change. For The Green Interview, I'm Silver Donald Cameron. See you next time.